What's up, everyone? Welcome back to U.S. Armed Updates. The Supreme Court just agreed to review a case that challenges one of the most controversial pieces of gun legislation that's been on the books for nearly a century, the National Firearms Act. I'm talking about Rush v. United States, and this case directly challenges the NFA's restrictions on short-barreled shotguns and short-barreled rifles. This is different from the silencer shop case you've been hearing about. This one just got scheduled for the Supreme Court's December 12th conference. Before we dive in, hit that subscribe button, because December is shaping up to be massive for gun rights. Let's break down what's happening and why it matters. Let me explain what the National Firearms Act actually is. Passed in 1934, the NFA was one of the first major federal gun control laws. It didn't ban certain firearms outright, but it created a registration and tax system that made owning specific weapons extremely difficult. Under the NFA, items like machine guns, suppressors, short-barreled rifles, short-barreled shotguns, and destructive devices require registration with the ATF. You have to submit fingerprints, photographs, pay a $200 tax stamp, and wait months for approval. Back in 1934, $200 was equivalent to about $500 today. The point was to make these items so expensive that average Americans wouldn't bother. For 90 years, that's exactly how it's worked. But now the Supreme Court might finally review whether any of this is constitutional. Rush v. United States stems from a criminal conviction. Mr. Rush was arrested for several crimes, including possession of an unregistered short-barreled shotgun. He challenged his conviction, arguing the NFA violates the Second Amendment. The district court ruled against him. He appealed to the Seventh Circuit, and here's where it gets frustrating. The Seventh Circuit said short-barreled shotguns aren't protected by the Second Amendment because they're dangerous and unusual. They cited a 1939 Supreme Court case called United States versus Miller. The Seventh Circuit's reasoning was that these aren't bearable arms protected by the Constitution. Think about that. A shotgun with a 16-inch barrel is fine, but 15 inches? Not protected. You go to federal prison. The length of a barrel doesn't fundamentally change what the weapon is. But that's the reasoning courts have used for decades. Mr. Rush appealed to the Supreme Court, and surprisingly, they agreed to consider it. They scheduled it for December 12th. The question before so are short-barreled rifles and shotguns in common use? The government will argue no, that these are unusual weapons for criminals. But here's the problem. They're only uncommon because the government spent 90 years making them difficult to own. That's circular reasoning. Also notice unregistered. The case isn't just about owning these weapons through NFA hoops. It's asking whether the government can require registration at all. If the court rules the Second Amendment protects these without registration, that calls into question the entire NFA scheme. The DOJ filed arguments defending the NFA restrictions. They're saying these weapons are dangerous and unusual, and that historical regulations support restricting them. They're leaning on that 1939 Miller case. But the legal landscape has completely changed since 1939. We've had Heller in 2008 establishing individual rights, McDonald in 2010 applying it to states, and most importantly, Bruen in 2022. Under Bruen, the government can't just say something's dangerous. They have to show a historical tradition of similar regulations. For short-barreled weapons, that tradition is shaky. For most of American history, there were no federal barrel length restrictions. The NFA in 1934 was the first attempt, done through taxation. The DOJ is defending a 90-year-old law using 1939 arguments in a legal environment created by 2008, 2010, and 2022 decisions. Their position doesn't hold up under Bruen. This isn't just about short-barreled rifles. It's about whether the government can make constitutional rights so expensive and burdensome that average Americans can't exercise them. Imagine if you had to pay $200, submit fingerprints, wait months, and register with the government every time you wanted to speak publicly. Nobody would say that's consistent with the First Amendment. But that's exactly what the NFA does with the Second Amendment. Beyond constitutional problems, there's practical absurdity. A 16-inch barrel is legal. 15 inches is a felony. You can pin a muzzle device to reach 16 inches legally, but if it's not permanent, federal prison. None of this makes anyone safer. These restrictions don't prevent crime. They create technical felonies for law-abiding gun owners who made mistakes. If the court rules these restrictions unconstitutional, it sets precedent for challenging magazine limits, feature bans, and assault weapon bans, all based on the same logic. The court scheduled Rush for their December 12th conference. A conference is when justices meet privately to decide which cases to take. December is court is whether they could deny Rush or GVR it, send it back to reconsider. But the fact that a criminal case like this is getting conference time is significant. It suggests some justices think it raises important questions. With other Second Amendment cases in December, the court might decide it's time for clarity. Recent legislation eliminated the $200 tax for certain NFA items. This changes everything. Part of the government's justification was that the NFA was a tax measure using Congress's taxation power. But if the tax is gone, that justification fails. It looks more like registration and restriction than taxation. This affects the Bruen analysis. If the NFA was justified as taxation in 1934 but the tax is gone, the government needs different historical justification. They can't point to historical taxation examples anymore. They'd need historical registration requirements or barrel length restrictions, which don't exist. The timing is interesting. Legal and legislative landscapes are shifting as the Supreme Court considers this. Nothing has changed yet. The NFA is fully enforced. Possessing a short-barreled rifle or shotgun without proper registration is a federal felony. Don't assume rules changed because this case is being considered. If you own NFA items, keep your paperwork in order. Keep approved tax stamp copies and documentation. If you travel across state lines with NFA items, follow proper ATF notification procedures. If you're considering NFA items, the process still exists. You still submit forms and wait for approval. Do not possess an NFA item before approval. Stay informed about this case and the Supreme Court's decisions. Rush vs. United States is one of the most significant challenges to federal gun control in decades. The NFA has been on the books nearly 90 years and courts have mostly rubber-stamped it. But the legal landscape changed dramatically after Bruen. Courts must apply real constitutional analysis now. Whether the court takes this case or not, the conversation is changing. More people recognize these restrictions are arbitrary and constitutionally questionable. More cases are being filed. December 12th is an amendment. huge